Department of Labor or the city. There are time limitations, so just know if you're going to file one of these, there are time limitations depending on what claim you're going to bring. Is it Title VII? Is it an ADA? So if you're going to bring one, make sure you go in and look at those. And I'll tell you, I could spew them off to you, but I, even today, look absolutely every time that I have some claim I'm going to file. I go back to the books. What's the statute of limitations on this? So I could have this in there, but I didn't put it in there because I want you to go back in every time and look so you don't blow and miss one of those. If you don't file the administrative claim, it's a bar to the later federal court action. You can file the federal court action, but then if you have me on the other side, I'm going to file the failure to exhaust and say you didn't file your administrative remedy and you didn't pursue it, and the courts enforce that. So you do have that administrative hurdle you have to go through. When you bring the administrative claim, you have a couple options. Once you bring the administrative claim, you can wait until the agency issues its decision and then issues you the right to sue notice. Or you can, within, depending which type of claim, wait 60 or 180 days. And if they haven't issued you your decision and the right to sue notice, you as the employee representative can go in and ask for that right to sue notice so you can move on and file your legal action with the court. Or you can try and convince right away the EEOC, don't even bother investigating this, I want my right to sue notice, and then not wait the 60, 180 days or wait the days for the decision to come out. I'll tell you, as an employer, I'm sitting here waiting on some from the EEOC that have been there 15, 17 months. As the employer, we don't have the ability to go to the EEOC and say, give that person the right to sue notice. That's only something that the EEOC has afforded to the employees. So you get to make that decision if you're representing the employee, whether or not you want to get that right to sue notice and move on to the federal courts or not. And then just know once you get that right to sue notice, there are time constraints of when you need to file your federal lawsuit, your state lawsuit, generally speaking 90 days from when it's issued. A few little exceptions, but again, go back to the rule. Independent contractor versus employee, depending on the type of employment matter we're dealing with, Fair Labor Standard Act, ADA, Title VII, EPA, there are different tests that the courts employ to have a determination made, is this person an employee and you needed to pay them versus pay them as an employee, or let them be an independent contractor, just pay them their sums and issue 1099s. Depending on the type of claim, there's a 20-factor test, an 11-factor test, there's lots of different tests that look at different things, so just know when you're looking at whether or not somebody is an independent contractor that your employer is hired or not versus an employee, you really need to go in and look at those factors. We certainly have state law definitions on who is an employee, and I've cited some of those, so whether or not you fire somebody and or you sever the relationship and they come back and say, well, I want unemployment compensation, you say, well, you were never my employee, I just hired you to clean the apartment buildings as an independent contractor. The Department of Labor is going to look at, well, were they an employee or were they an independent contractor? And there's a whole bunch of different tests out there. Workers' compensation, same thing. Is this person an employee when they got hurt or not? A lot of different tests out there. What I really want you to take away from this piece is just to know if you're advising your businesses or if you're meeting with people, you really need to go in and research, is this person an independent contractor? Are they an employee? Because there's some substantial penalties if you get it wrong as to they were actually an employee. Those are just the factors that the courts are going to consider in South Dakota. I could speak a whole hour on this issue, and I just mainly just want to give you a 101 of some things to consider in employment law. Who has the tools, who controls the hours, things of that nature. Contract negotiations in terms of independent contractors. If you are going to have your client have an independent contractor, go back in, read the rules on what needs to be in the contract. A lot of different factors, take those factors point by point and just say, okay, this person who's going to clean those apartments really is an independent contractor. Well, how are we going to have that set forth? What is going to be the evidence of it? Put it in an independent contractor agreement. Look through the factors and make sure you list the factors in that contract, and you're going to be able to better support that this person is not an employee, they're an independent contractor for any of the federal claims or the state claims, the work comp, the unemployment, etc. Employee handbooks, very briefly. There's no law that requires an employee handbook. I generally tell my employers, you know, if you have 15 or more employees, it might be a good idea. I'm not one who likes an employment handbook that's super thick. Get the basics in there. You don't have to have them. You do have to have that EEO poster that, you know, you go into the break room and it's there. I mean, that's really the only thing you have to have out there. If you have a few employees, there are a lot of good handbooks out there to kind of model after, and that's my kind of guide of when you might want one, is when you have about 15 employees. Make sure you periodically review those handbooks. Tell your clients laws change constantly. Things that you didn't think you had to have in there, you need to have them reviewed, and have them reviewed by somebody who does employment law, not just business practice law, because they'll be more familiar with what needs to go in there. So periodically they should be reviewing them and have somebody doing it. Handbook best practices, if you're going to have it, I can't tell you how important I think it is to make sure you have in your handbook then what the reporting procedure is. If there is discrimination complaints, harassment complaints, who are they going to take those complaints to? That should be something that you do have if you are going to have an employment practice. Other issues, and I don't really see a time, and I didn't bring my phone up, so am I sitting? Okay, 10 minutes. Other employment issues, I just wanted to very briefly give some guidance on maybe some best practices if you're going to hire employees, or if you're going to talk to employers about how to hire employees. Screening employees, document and terminating employees. That's the last 10 minutes of my presentation here today. You need to know when you're screening employees that all of the protected classifications that we were talking about, it's best to not know anything about those protected classifications, and think about what you don't want from the information that you're getting with the employees. Facebook, if you're going to go in and look at the Facebook stuff, there's going to be a lot of that stuff on there, and know that if you're going to go in and look at their Facebook type of postings that they have. Because once you see it, it's kind of hard to undo. So when you're screening your employees, if you're going out there and looking, or screening people you're going to hire, or your employer's going to hire, it's awfully hard once you've already seen it. So recommendations, maybe wait till after you've interviewed the candidates before you go in and start looking at their social media. Tell them that you're going to go look at their social media. Make sure you treat them all the same. Make sure you do your searches all the same. Treat the bad information that you get during that social media search the same as you would if you would learn it in the interview. Maybe have a non-decision maker do the actual screening process instead of the person who's going to hire, say to somebody else, could you go look on the social media, because I don't want to look at these things, but I want to see if there's something out there I need to know, but I don't want to know about their race and their political affiliation and things like that. And then keep the records associated with the hiring decision, including the social media pages, because those do disappear or change. In terms of managing employees, and I think in South Dakota in particular, we, generally speaking, have good common sense. It's okay to employ your common sense. Important to document performance and conduct problems for all employees. Some basic things: treat employees how you would want to be treated, treat them equally, apply the policies consistently. Think through is how would you want to be treated. I think of new associates when you hire them. If you were in their shoes, how would you want to be treated in terms of performance and just making that decision of terminating eventually. So those are just some helpful hints in terms of managing. When you are going to terminate somebody, we all think we're never going to have to, but it happens. And so just some basic guidelines in terms of terminating them. It's important to document things because number one, it gives employees a heads up that this is coming. And number two, you can use it later to help defend the decision that you made. Is it required? No. Is it helpful when you're before the EEOC trying to tell your employer or the EEOC this is why and you have the documents to back it? Yes. Does it mean you can't try a case without having documents? No. It helps to sway the jury, it helps to sway the EEOC that yes, we actually had performance issues and they were documented. Just different things to, infractions, so you go ahead and put it if there's a particular code or conduct rule. Use employee best coaching, best practices when you're dealing with performance. Document those as soon as possible. Don't wait 4 months, 4 weeks, as soon as possible. Meet with the employee and go over the document that you're doing. Employers don't have to be with employee, it's just a good idea because it gives them heads up notice, but it doesn't have to be used, so you don't have to let them know you're doing it, but you know, it's a good practice if you're able to, but it doesn't have to be done. If your employer has a human resources department, have them work with the human resource department. Just remember, in South Dakota, we have contract employees and we have at-will employees. So we have employees who can be terminated for any reason or no reason, so long as it's not discriminatory, whistleblowing, work comp, those types of things would be the exceptions. And you have contract employees. So you really need to know who you're dealing with. Are you dealing with an at-will employee or a contract employee? If it's a contract employee, you may need to make sure you look through the contract under what circumstances he or she can be terminated. You know, like I said, you just want to make sure, while we can terminate employees, just know that there are times you can't. If it's in violation of a law, if it's in violation of FMLA, things of that nature. It's in retaliation of protected activity, so while you can terminate them, there are certain circumstances in which at-will employees can't be terminated for improper reasons, such as listed there. Like I said before, when you terminate employees, if you do it wrongfully, it's expensive. You have the back pay, you have possible front pay, you have emotional damages, you have attorney's fees, punitive damages, so it's a pretty high damage amount that can be recovered, so you want to make sure that you're doing it correctly. And like I said, it is never easy, but when you're going to go in and terminate an employee, you usually are dealing with an unhappy employee, so it's not going to be easy. Those people have people on their sides, and so they're going to be unhappy, and so you're going to have a lot of things that you're going to have to go in and deal with. When you go in and make the decision to terminate, go back and look at the personnel file. Does it say that employee is a great employee, there's nothing in there, and all of a sudden you've had no counselings of that employee, and that's all you have? So you want to go back, what documents do we have? Is there an employment agreement? What have we done with other employees? How long have they been there? Just a few different things to think about when you actually terminate that employee. And then when you actually terminate that employee, do it in a way that is fair, in a way that is respectful, follow the termination procedures that you have the person in there that should make the decision about terminating, communicate it, deal with the post-termination issues. Do you have documents that need to be returned? Do you have keys? Do you have security issues? All of those types of things. Consider severance agreements. There are two categories. There's for the people that are over 40 and those for the people that are under 40. If you're dealing with the over 40, then you've got to give them 21 days to review, 7 days to revoke under the Age Discrimination Older Worker Benefit Protection Act to actually get those age discriminations waived. Consideration, they got to get more than they're entitled to, that they otherwise would be entitled to. For confidentiality, we all think, oh, these severance agreements offers are all confidential. Well, not necessarily so. They're only confidential if there's a real dispute between yourself and the employee. So just keep that in mind. You can't just say, I'm going to terminate you, here's a severance agreement, and that's not admissible in anything. It can be admissible if you don't have a reason to offer them that severance agreement. There's a number of court cases out there that say that you have to have some type of dispute that you're actually offering the severance agreement. Otherwise, that rule of confidentiality and admissibility of settlement agreement is not applicable. So there's cases out there to read on that, but it's just kind of something a little different. Wrapping up here as quickly as I can. In terms of what you need to do with your employees, and your employers, I just wanted to make sure that you had an idea of what some of these employment laws are out there. So you can go out and advise your employers. You can now know how to deal with your own employees when you're hiring and firing and make your own decisions. That one came up, a lot of federal and state laws out there that you need to be aware of. Numerous employment issues that we have here in South Dakota and all over the country. I would open it up to questions. It's 2 minutes to. The only big thing I have here, though, is my disclaimer that my PowerPoint presentation, all these best practices, cannot be used against me or my clients when I'm defending the lawsuit that maybe you're bringing. And this is a picture of my really, really good friend, Stephanie Pocock, who I've enjoyed litigating cases against for years, but oftentimes she has the employee, I have the employer, and I certainly hope I didn't say something that's going to hurt my clients later. So one of the best parts we have here in South Dakota about practicing is getting to get to know people that you litigate against. and going out and having lunch with them or talking about their kids, because that is what truly makes the practice of law here in South Dakota enjoyable, is getting to know the attorneys. The clients come and go. You may have a client now and you'll never see that person, but the relationships that you form with the other attorneys, how you handle yourself with the other attorneys, is going to continue. So, happy to answer questions after this. I know we have some swearing in things to go, but I just wanted to give you an overview of things that I wish I would have known when I first got out of practice or out of law school in terms of employment law. So, thank you. And I'll give you extra notes then for next time. Otherwise, we'll do them all later.
All right, thanks so much, Lisa, for that great presentation. A couple of announcements. At the back of your information packet, there's an evaluation form. I would ask that you please fill it out, and especially at the bottom, if you have recommendations for future topics that you'd like to see at these events, please write that down and really consider those and take that into account in future planning for CLAs. Secondly, we have the statewide swearing-in ceremony this afternoon. That's at 3 p.m. at the Capitol. For the 4 of you that are being inducted, if you could head over, you want to be there about 2:15. And if anyone needs directions on how to get to the Capitol, just come see me afterwards, and I can help you figure out how to get there. I want to say a couple thank yous to Abby Howard and Matt Campbell, who are both on the planning committee. They're not here today, but they did a lot of work to make this event happen. And then also Nicole Ogan and Deanne Stevens. They do a tremendous amount for our state bar. They're the women sitting out here. Please thank them. They really make the state bar happen. So please express your gratitude to them. And then finally, the Young Lawyer Boot Camp. For the young lawyers here, please save the date. It's February 26th. 3 locations. That's happening in Sioux Falls, Pierre, and Rapid City this year. So please save the date for that. And thank you.